Do we have Ms. Strock here? Do we have everyone here, and are we ready to proceed? Ms. Moss?
Yes.
Okay, and Ms. Strock, are you here?
I'm here.
Okay, great. Then Ms. Moss, you may ask your next question.
Ms. Strock, I'd like to turn your attention now to Guilford County's experience during the March 2016 primary. Do you recall how many votes were cast in Guilford County in the March 2016 primary?
I don't recall specifically.
Okay. If we could bring up LX02, or I'm sorry, LX202. And this is a printout from the State Board of Elections website for Guilford County for that election. Does this refresh your recollection on how many votes were cast during that primary? And how many votes do you recall Guilford County having during that primary?
122,897.
And do you recall, based on your review of the provisional ballot spreadsheet that we've been discussing, how many reasonable, excuse me, how many reasonable impediment forms were submitted with a provisional ballot that were not counted in Guilford County?
I believe, to the best of my recollection, that there were 10. That's my recollection, that there were 10 that were not counted.
Okay. And if we could bring up LX 192, which again is a summary exhibit based on JX 792, which is the provisional ballot spreadsheet from the March 2016 primary. Ms. Strock, do you recognize this exhibit?
I do.
And is the data in this exhibit, to the best of your knowledge, pulled from and representative of the data that is in JX 792, the provisional voter spreadsheet dated June 2nd, 2016 for the March 2016 primary?
Yes, it is.
Similar to your experience with Alamance County, in March of 2016, would the State Board of Elections, working with Guilford County's County Board of Elections, have been able to obtain IDs for these individuals if tasked to do so?
Objection calls for speculation.
The objection is overruled.
Just as with Alamance, the voter outreach team in the 2016 election was tasked with any voter in any part of the state. So no, they would not have considered that burdensome. And if tasked or asked to help provide an ID, they would have certainly assisted.
Okay. And we can take that exhibit down. Thank you. Ms. Strock, do you recall whether or not in Guilford County between 2012 and 2016, whether there was an increase or a decrease in early voting sites in that county?
I do recall, because that was a big concern of ours in 2016, as we wanted to make sure that we did as much as we could to increase access. So I believe in Guilford County, I'm certain that the number of sites, and I believe the number of hours, went up in 2016 from 2012.
And do you have did you stay on top of the early voting sites that were offered in Guilford County in the 2020 election?
I did.
And to your knowledge, did the early voting sites in Guilford County go up from 2016 to 2020?
Objection on lack of foundation. I don't understand what stay on top of meant.
The objection's overruled.
I believe I'm not sure that the number of sites went up, but I am certain that the number of hours dramatically increased in Guilford County from 2012 and 2016.
If we could pull up LX 209. Ms. Strzok, do you recognize this document?
I do.
And what is this document?
This is a document that is maintained and kept on the state board's website, and it lists the locations and the hours for all one-stop voting sites. This is done for every election, and so by county it shows you where the one-stop site will be, and it provides the schedule for that site.
And this particular document that is available on the State Board of Elections website, which election does this show the one-stop sites and hours for?
This is for the November 6, 2012 election.
And if we could now pull up LX 219. Ms. Strzok, do you recognize this document?
I do.
And again, what is this document?
This document is, again, it's the same document. It is a list of one-stop early voting sites in each county, and it provides the location and it provides the schedule of hours that site is open.
And for which election is this document that is available on the State Board of Elections website? Which election does this show the one-stop sites for?
November 8th to 2016.
Okay. And then finally, if we could pull up LX 210. Ms. Strzok, do you recognize this document?
I do.
And again, what is this document?
This document is a list of the one-stop early voting sites per county, and lists the sites and the hours of operation for each of the sites.
And for which election is this document?
For the November 3rd, 2020 election.
And if we could now pull up LXD 220, this is a demonstrative exhibit that's based on the 3 documents that we've just looked at. Ms. Strzok, does this demonstrative reflect your understanding of the information that's available in the 3 documents that we just reviewed regarding the one-stop sites and hours that are available in Guilford County in the 2012, 2016, and 2020 elections?
It does.
And from November 2012 to November 2016, is it consistent with your experience and recollection that the number of one-stop sites in Guilford County went from 22 to 25?
Yes.
And then I believe you testified that, to your knowledge, the number of one-stop sites stayed the same between 2016 and 2020. Is that right?
Correct. Correct.
But that the hours increased?
Yes, dramatically.
We can take that exhibit down. Thank you. In your experience as the State Board of Elections Executive Director, when you're considering one-stop sites for counties, was it typical during your tenure for counties to have the same number of one-stop sites in a presidential election year as they would have in a non-presidential election year? So odd number versus even number years?
No, and in fact, usually when we're looking at providing data, or at the time when I was there, my experience of providing data, you compared elections. So if we were looking at the 2014 election, we would look back at the 2010 election. Or if we were looking at the 2016 election, we'd look back at the 2012 election to try to make sure that we are, because that's sort of a gauge of you are more likely, certainly the turnout results will show that you're going to have likely more turnout in a presidential election year than a midterm election.
And taking a step back, as the executive director of the state board during your tenure, what were some of your goals in how you administered the elections that you had responsibility for?
Well, I think the number one goal, and I think any election, is that you want to make sure that you have as much access and opportunity for people to vote. And that the goal by doing that is in providing as much information to the counties that they need to make sure that that happens. So that is a primary goal, is you want to, where we can increase turnout, where we can make sure we have, where people are voting, and just having sites that are in places that will accommodate that. That was certainly a goal during my tenure, is to make sure, regardless of whatever the election laws were, to make sure that we tried to increase access and opportunity.
Did you have responsibility when you were the State Board of Elections director in safeguarding the integrity of the elections?
And yes, and that is certainly another very important role of along with access and opportunity. You want to make sure that every vote is counted and that only eligible voters cast ballots in the election. And so the types of things that we would try to do, ensuring the safeguarding, and safeguarding means a lot of different things. Safeguarding can also mean making sure that your voting equipment is accurate and that you are auditing results. So there are many things that you can do and have to do, that the state and counties have to do to safeguard elections.
And have you had any experience in having to conduct investigations into election issues that could have affected the results of an election?
I have. As I indicated yesterday, I started off at the State Board of Elections as an elections investigator. And with that, one of the primary responsibilities was helping identify and investigate potential allegations of election violations. And when I became executive director in 2013, in 2014, we had a very small investigative staff that we were appropriated positions that I was able to fill in 2014 to have a full investigative team. And so I oversaw that, the elections team that was put in place, that their primary goal was to investigate irregularities and to ensure that we had necessary safeguards in place. And through that, there have been several investigations that I have either overseen or certainly been part of.
Were you involved in the investigation of McCrae Dowless in the 9th Congressional District?
I was.
And when did that occur?
Well, McCrae Dowless we had complaints since 2016 and before that, probably with related things. But in 2018, the 2018 general election, we received information about the possibility that Mr. Dowless was engaged in illegal ballot harvesting in the 9th congressional race, in assisting the Republican candidate in that contest. And so the state board at that time, during the certification of that election, voted not to certify the 9th congressional election and to engage in a full investigation of the potential allegations to see if there was merit, and if there were significant violations that could impact the outcome of that contest. And so I was tasked by the then chair of that board to lead that investigation and lead that hearing after our investigation determined that there were significant violations that had been committed in Bladen County in that congressional district that could have altered the outcome of that election. I was part of the on the ground investigation, and I helped conduct the hearing into those matters before the state board.
And in conducting that investigation, what did you determine McCrae Dowless was doing that you considered to be irregular?
North Carolina law in 2018 and consistent now prohibits what we would call ballot harvesting. It prohibits several things, but it prohibits an individual from taking a voter's voted ballot for any purpose unless that is a family member of the voter. And what we found in the 9th congressional district is that there was an orchestrated, I would call it a scheme by Mr. Dowless, that he employed a number of people to go out and initially, from a list of voters that he wanted to target, to go out and try to get those voters to request an absentee ballot by mail. He then had, understanding the fact that the County Board of Elections will then mail a ballot to those individuals in a short time after those requests are then delivered to the county board, which his workers did. They delivered the request to the Bladen County Board of Elections. And then he had tasked those workers with going back to those voters at a time when he was certain that they would have received their ballot. He would have his workers go and tell the voter that they could vote their ballot. They would serve as witnesses, and then they would collect that ballot and they would return it to Mr. Dowless personally. And at that time, he would then either have someone put those in the mail, or on occasions take them and deliver them to the County Board of Elections. Several of those things are violations of the law. And in addition to that, what we were able to find during our investigation is that some of these ballots had not been voted by the voter. They had been obtained in blank form, or that they were voted potentially and no one witnessed it, and those witnesses that appeared on the actual absentee ballot had not in fact ever witnessed that voter vote the ballot. All of those things are in violation of North Carolina law and would make some of those ballots subject to not being counted because they were not cast in accordance with law, or in some cases not cast by the actual voter.
And in your experience, your firsthand experience conducting that investigation, would the existence of a photo ID requirement have made a difference in this situation?
I believe that it would have made Mr. Dowless's job it would made it harder for him to do. He was able to carry this out with the witnesses, but what he would have had to do additional to that is he would have to, in order to have an absentee ballot that complied with photo identification, he would have to have the voters give him a copy, or give his workers a copy of that identification, either with their request or with their absentee ballot. And that might be a little bit of a harder sell for him to be able to conduct his operation, because you might have individuals that might not want to give up their personal photo identification or documentation to someone, because most of these people did not know who these individuals were that they were giving their ballot to.
I now want to turn your attention to some criticisms that have been lodged by plaintiffs' experts against your implementation of the March 2016 photo ID. Well, I should step back and say that you implemented in the March 2016 primary that have been lodged against your implementation of House Bills 589's photo ID requirement. To the extent that a criticism has been made that no efforts were made to educate voters about the fact that they no longer needed to show photo ID in the general election in 2016, do you believe that such criticisms are valid?
I don't, because, and there's a lot of evidence to what the state and the county boards did. The decision in the Fourth Circuit in that case, I believe, came out on July 29th. And my best recollection is that we were about to conduct a statewide training seminar. That was the purpose of that was at that time to continue to train people on the need to have their outreach efforts and get ready for the general election. And once that decision came out, we had to immediately switch gears, because it became very clear to us very quickly that we had advertising that was going on that was telling people that they would have to show up and provide a photo ID. We had literature that was out in the communities that was going to have to be, we needed to stop. And so we immediately started to make efforts to notify all of the individual or the groups that we had provided literature on the need to show photo ID, to get them to stop distributing that and providing additional things that to show that they didn't have to show photo ID. We included, and after, in every general election, and some primaries, we print what is called a judicial voter guide. And the judicial voter guide it goes out since 2004, I think was the first time we started mailing those. They go to every household in the state, not just to registered voters, and it provides information on registering to vote, pertinent information about the appellate judicial races, but also voting information. And so we use that opportunity because we knew that we needed to be able to reach not just registered voters, but everyone that might show up and vote in the general election. So we prominently used that voter guide as an opportunity to show and to distribute out to every household that photo ID would not be required in the 2016 general election. And as I said, with our statewide conference, that happened very close after that. It was not, I can't remember the exact date, but it was just a few weeks. And so the message at that conference was ensuring that we were using our partners, the 100 counties, to also get that message out, that you wouldn't have to show a photo ID. So I do believe that information shows that we made every effort we could to try to get information out to as many people as we could to know that they would not have to show photo ID.
And before the Fourth Circuit's decision came down, which struck down the photo ID requirement, had there been any discussions or deliberations at the State Board of Elections on conducting further training in the counties about how to implement the photo ID requirement and the provisional ballot process based on information you had learned from how that process had worked in the March and June primaries?
Um, After every election, and certainly after an election where we were initially, for the first time implementing photo ID, we always are wanting to, we do, and we learn a lot through the whole canvassing project, that process that we do, because that is a time when our state board staff during that election worked, um, with the counties individually to look at what issues they had in the election, if they had any discrepancies, that's including provisional or any other, and try to work with them to see and identify any problems that we need to try to correct for the next election. So certainly that was done after the March primary, is looking at all those issues that might have come up through any of their interactions with the counties. And then we also, our outreach team immediately, and I believe, in my recollection, was immediately, maybe the day after, we wanted to obtain information on the reasonable impediment declarations, and that was their task to try, okay, these are the people that now we know that have shown up, and have told us that they couldn't obtain photo identification. And so efforts were made immediately to try to reach out and work on, we call it the reasonable impediment declaration project, if I recall correctly, um, to try to get those individuals equipped for the next election.
And is there any reason why your efforts to obtain to help voters who indicated they didn't have a photo ID through this reasonable impediment project, as you've called it, or to train election officials in the various counties on what they did right and wrong with the reasonable impediment process and the ID requirement, is there any reason why you did not continue forward with those efforts?
Um, the March primary happened, and then we had a special congressional primary in June of 2016, early June. And that election, I believe, was certified on July 27th. And so all of the things that we do in conducting an election, when you had all 100 counties participating in that congressional primary, those efforts ended where you had photo ID also going on in that primary. That certification ended with on July 27th. 2 days later, the Fourth Circuit struck down the photo ID requirement. And so at that point, our efforts were then stopped at trying to implement photo ID, and our efforts went to trying to implement photo ID with our counties and their precinct officials and the public in general.
As the executive director of the state board at the time, would it have made sense to you to continue focusing on implementation issues related to a photo ID law that had been struck down?
No, in fact, I think that would have caused a lot more confusion. As I think I've testified earlier, when you're dealing with precinct officials and people that work in elections that are not the staff of the county board, you don't have all that many opportunities to train them for the next election. And general elections are very, very, very important in any election year, especially in a presidential election year. So what we wanted to do is make sure that the efforts that we had going forward were looking at an election that would not have photo ID, which was different than what they had just trained on for the June primary and the March primary. So our efforts completely changed after the Fourth Circuit decision, so that we could try to make sure people were equipped for the election laws that would be in place for the general election.
Okay. And in terms of actually implementing the reasonable impediment process that was in place in the March 2016 primary, did you have tools available to you as the executive director for how you could provide guidance or even mandates to the county boards on how they were to evaluate those reasonable impediment declarations?
Yes, as executive director, the executive director of the state board has, prior to my tenure, and continues to issue what we call numbered memos. And numbered memos are directives from the executive director, and the counties are to follow those directives. And the very first numbered memo that I issued in 2016 was to deal with the reasonable impediment process and the county process in how they would consider those provisional ballots with the reasonable impediment declarations.
And had the law not been enjoined, would you have had the ability to issue additional numbered memos to provide instructions to the counties, had the counties deviated from how they should have implemented the reasonable impediment process?
Yes.
When you were the executive director and during the March 2016 primary, can you describe for the court what the county boards of election, what, how many members they had and how they were made up in terms of political party?
Yes. In 2016, the county board of elections were 3-member boards. 2 members were the party of the sitting governor, and the other party would be the minority party. So the 2 major parties were represented. And so it would be the 3-member boards that would conduct all of the business of the county board of elections.
And to your knowledge, do the county boards still consist of 3 members?
No.
What do they consist of now?
They are now 5-member boards.
Okay. And given that the governor is a Democrat, does that affect the political makeup of the county boards?
Right. It would be the same concept of the majority of the board. 3 members would be Democrat, and 2 members of the board would be the minority party, the Republican Party.
Okay. And when you were the executive director, who had responsibility, I guess, for adjudicating the provisional ballots that were cast during the March 2016 primary or any other election that you were the administrator of?
The adjudication of the provisional ballots is a responsibility of the county board themselves. The staff will do research and provide information for them to make the decisions, but the decisions are to be made by the county board members.
And can the state board of elections, and did you ever have occasion as the executive director of the state board of elections to tell county boards that they should count certain ballots that they were not going to count?
Excuse me, did I personally?
Yes.
Yes, ma'am, I did. So after the March primary and the counties go into their canvassing of the election, and I think I stated earlier, several staff on board at the State Board of Elections get reports on provisional activity that's going on in the counties to see that they are actually doing that work. At the point that the county boards made their decisions about provisional ballots, I had requested that all of the reasonable impediment declarations be uploaded to the state for our review in preparation for the state's canvass and certification. And as part of that, because I wanted to make sure, as the author of the numbered memo that provided the guidance to the counties, I wanted to look at those myself, as many as I could, to see if county boards made the right decision. And I did not review all of them. They came in at different times, but I do recall I reviewed a number of counties reasonable impediment declarations. And if I saw that it appeared to me that they had not made the right decision on basically not counting it when they should have counted it, I reached out to those counties and provided my reasoning of why that decision was wrong. And what appeared to me to be the fact that they had made the wrong decision, then they needed to have their county board recanvass those results. I did that on reasonable impediment declarations. That is also part of the provisional audit that the state board staff did during my time there, and I'm sure they probably could still do, is to ensure that provisional ballots that have been cast, if there have been decisions that were wrong decisions and they had not counted provisionals they should, the state board staff, part of their provisional audit is to notify those counties and give them an opportunity to recanvass and count those ballots.
Ms. Strzok, I appreciate your time with us this morning. I have no further questions for you now. I may have some more after Ms. Riggs conducts her cross-examination.
Thank you.
Riggs, would you like to start now, or do you want to wait till 2?
I'm happy to start for a few minutes,
Okay, go
or
ahead.
we could come back a few minutes earlier than 2.
Why don't you just go until 12:30 and we'll start back at 2.
Excellent. Ms. Strack, I'm unmuted. Okay, excellent. Ms. Strack, I'd like to talk to you about your personal connections to this case. As you discussed with Ms. Moss on direct, you were the executive director during House Bill 589's implementation, correct?
Yes, I was.
And you were executive director when the complaint was filed in the lawsuit challenging House Bill 589, correct?
I was.
And you were executive director still when the Fourth Circuit invalidated House Bill 589 as intentionally racially discriminatory. Is that right?
I was the executive director when the Fourth Circuit made their decision, yes.
You're married to Phil Strack, isn't that correct?
That's correct.
He's an attorney for Ogletree Deacons.
He is.
And Mr. Strack defended House Bill 589 before it was struck down as intentionally racially discriminatory by the Fourth Circuit. Isn't that true?
He was a legislative attorney, yes.
He was the attorney defending the House Bill 589.
Yes.
And you would consider Representative David Lewis a close family friend. Is that true?
Yes, David Lewis has been a friend of my husband's for a long time. He is a family friend.
He was the best man at your wedding, correct?
He was.
And do you understand that Representative David Lewis voted for House Bill 589?
I'm sure that he did. He was chair of the Election Law Committee.
And that he voted for Senate Bill 824?
I'm not surprised that he did.
And you were aware that Representative Lewis was a defendant in this case when you signed on to be an expert, isn't that correct?
I'm not sure if he was in the legislature at the time. I was asked to do this in August of 2020, I believe. So he may have been.
Okay. You're aware he was a defendant in this case for the bulk of this litigation, correct?
Correct.
Now I'm actually probably at a point where it makes sense to stop for lunch.
Okay, then that's what we'll do. Yeah, go ahead and break until 2 o'clock. Hope that you all have a good lunch, and we'll see you back here then.
Thank you, Your Honor.